giving the YouTube link. Kavita?
Yes, ma'am. I'm going to start.
Yeah. ఒక్కసారి తను ఇవ్వంగానే we'll start.
Naveen,
Kavita, ఒక్క నిమిషం. One second. Let Vidya start the YouTube live. It's live now.
Yeah, it's live, madam.
It's live now. Yeah, okay. Yes, Kavita. We'll start now.
Okay, ma'am.
Can you share me that YouTube live link? I will also share to some of them if you are.
Yes, sir.
Yes, sir, I'm sharing.
I'm going to start now.
Yes, Kavita.
Good afternoon, everyone. Respected Principal, Vice Principal and Head Department of Commerce, and Convener of Dr. Rashmi R, Ms. P. Sunanda, IPC Coordinator, faculty of other different colleges, and my dear friends. I, Dasari Kavita, on behalf of the entire team of the College of Kasturba Gandhi Degree and PG College for Women, welcomes you all for today's event, Faculty Development Program on Intellectual Property Rights. This session mainly focused to understand how IPR laws are useful to the common man. I also welcome the guest speaker for the day, Mr. Naveen Kumar, advocate and IPR attorney for the session. Thank you, sir, for being with us today. Now, I would request Dr. Rashmi R to give welcome address. Over to Dr. Rashmi.
Thank you, Kavita. Good afternoon, one and all. At the outset, I'd like to congratulate IQAC and Department of Commerce for conducting this webinar on intellectual property rights. I also welcome and thank Mr. Naveen Kumar Anumala, an attorney with double graduation, the speaker of this day. I thank you very much, sir, for being the speaker of today's webinar.
Thank you.
And it is my privilege to introduce Mr. Naveen Kumar Anumala. Sir is an attorney with double graduation of both engineering and law. His qualifications are BE, Biomedical Engineering, with LLM in Corporate Law. Sir has also got a diploma in IPR from Nalsar University. He is also having a diploma in electronics. He is a registered patent attorney and trademark attorney with Government of India and founder of Oscar Global Research Services, Oscar Legal Services. He has been working in the area of intellectual property rights since 2005 and has guided many corporate companies and individuals to secure patents, trademarks, and copyright strategically and successfully, and has helped many companies in implementing legal compliances within the organization. He has vast experiences in handling legal issues pertaining to companies in various segments, IPR, civil, and other criminal matters before courts, tribunals. He has conducted police raids and various trademarks and copyright violations in Hyderabad and outside Hyderabad as well. So we are very indeed, it's a privilege to have you with us, sir, today. And I welcome all the participants for today's webinar. I also thank the ICT team, to Mrs. Sunanda, Vidya Lakshmi, and Mangavani for facilitating this webinar. I hope all of you have a good session. Thank you.
Thank you very much. Thank you very much, Ms. Rajeshri, for a wonderful introduction. Thank you very much.
Thank you, Mr. Naveen. Thank you very much.
Thank you, ma'am. Now I would hand over the session to Mr. Naveen Kumar, the speaker for the day.
Thank you, Kavita. Can you please enable the screen share so that I can do the screen sharing?
Yes, sir. Yes,
It's already enabled, sir.
Enable, yes.
Yeah.
Can see my screen?
Yes, sir. Yes, sir.
Okay. Good afternoon, one and all. Myself, Naveen Kumar, and thank you all for attending this part of the session. So in between, if you are having any questions during the lecture, in case if you have any questions or concerns, please feel free to interrupt me and ask me at any point of time, because this should be more like an interactive session rather than one-sided session. Okay. So this is a very important topic for me because this is my bread and butter, and I have been in this industry since 15 years handling this intellectual property rights. So intellectual property rights majorly is an important part which it plays in everyone's life. So as I take you all through the session, you will definitely understand how these intellectual property rights is coming in our day-to-day life. So to quickly start off with, so I would like to inform you all that I am on a mission to help at least 10,000 entrepreneurs to secure value-added intellectual property services. Okay. So now what are intellectual property rights? So to begin with, these are actually patents, trademarks, copyrights, designs, geographical indications, and trade secrets. So these all together forms intellectual property rights. So many people often confuse IPR and patents, IPR and trademarks. So IPR means the complete or each and every individual segments together are called as intellectual property rights. So sometimes some people often get confused trademark with a patent and patent with a trademark. So after the end of this session, you will have complete clarity about each and every segment of the services, what they all belong to. Okay. So going forward with the next session. Uh, Here, in case if you see, everyone can understand that this is a mobile phone. A toy mobile phone, you can say, or a mobile phone. But in case if you see this as a mobile phone, this mobile phone which is being used on day-to-day basis for each and every individual is now carrying this mobile phone. Do you all know how many intellectual property rights are there in this mobile phone? I will give you an example. The trademark, the name of the mobile phone is covered under the trademark. So the trademark means it gives an identity of the brand name. So what the product belongs to. Okay. And I would request all the others to please mute yourself so that others gets focus diversion. Excuse me.
Yes, sir. All are muted now, sir. You can speak.
Muted. Yeah.
Yeah.
So it's trademark. And now whatever the technology that is involved in this patent, this mobile phone, this is covered under the Patents Act. So the mobile phones do have covered so many patents that are there in the day-to-day life, and there are many litigations that are still going on in different courts in all across the globe on patents technology, which one company copies the other person's technology. So in order to involve these kinds of diversification of patents in terms of protection, legal protection, due diligence should be very, very essential. Now when it comes to patents, so what is patent? Patent is a technology involved in the product. So patents and trademarks are two different things. Trademarks only gives the identity of the product, name of the product. If you see, if you go with the cool drinks, the Coca-Cola, that's a brand name. Okay. Now the design, if you see this mobile phone, this is a unique shape car mobile phone. Now if you see this shape is covered under the Designs Act. So this is a design. So now if you can differentiate between trademark, patent, and design, the fourth one that comes up is copyright. The software programs that are there in the mobile phone are covered under the Copyright Act. So if you all understand the kinds of intellectual property rights that are right now covered in the complete one mobile phone, which you are carrying on a day-to-day basis, it has 4 different intellectual property rights involved in that. Okay. So going ahead with this small introduction regarding what is patents, trademarks, copyrights, and designs, we will move ahead with the next topic. What are inventions? Inventions. Now, when I talk about patents, patents are nothing but inventions that are protected and granted by the government. So the patent is a right given by the ma'am, the moderator, can you please take care of this? Yeah. Thank you. So inventions related technology patents. So now, whenever there is any shape related that is protected under the Designs Act. Now there is a goodwill that is related to a product. So whenever there is a goodwill, then that is covered under trademarks. So the books, music, video, all these also covered under the Copyright Act. And trade secrets, geographical indications, I will give in depth coming to the next segment. So now, whenever we talk about the patents, now understand that in only when technology is involved, then only that is covered under the Patents Act. Okay, sorry for that. Now patents. So whenever there is a technical problem for any technical problem, and if there is any technical solution, one gets a patent for that. Okay, so understanding solutions to technical problems, and if your solution is unique, you get a patent. So normally, what are inventions? So if you want understand in depth what an invention means, so on a day-to-day basis, so many people are using so many gadgets, so many products, and in case if there is any problem that is continuous and persistent, and then in case if there is no such solution to such a problem, then that solution, if someone finds out, then that solution is a technical solution that is qualifying to a patent only if it is unique. The criteria is it should be unique. So that's how the patent can be granted to an invention which is new. So that has to actually undergo so many processes and procedures to get a patent granted. Now, a patent can be obtained for an invention which is new. It can be a product or a process. An inventive step has to be there. So as I mentioned earlier, technical advancement or an economic value or both. Now, whenever I am inventing something, it should also have a technical advancement. Unless and until it is a technical in nature, this cannot actually come as a this does not qualify as a patent application. Yeah. So now important thing is economic value. In case if there is some product that is in the market which is costing more than a lakh, and someone creates the product for at 20,000 rupees. Now there's a huge economic value that a end customer gets. So whatever the procedure, the process he has adopted to get that already existing product, but giving an economic value at advantage to the society, then even that they also get a patent for that. Now, industrial applicability. So, industrial applicability means I invent something that should be useful to the society. If it is not useful to the society or the industry, then I need not have a patent application for that. So, industrial applicability has a very, very important, significant role whenever a patent is considered as a right to be obtained. Now, what is not patentable? So, if you see that there are certain in Indian Patent Act gives a very specific definitions that inventions that are not patentable. So inventions that are contrary or to the natural laws. So many science students will appreciate that a perpetual motion devices. So perpetual motion devices means like there is no input but there is an output. So such kind of devices do exist. So they are actually contrary to natural law because without input there cannot be any output. But here there is no input but there is output. So such kind of inventions are not going to be patentable. And contrary to public, if it is something which is affecting the morals of public, that can be not be patentable. And if it is something involving the scientific principle or theory, that is also not patentable. And this is purely into chemical compositions. In case if it is a new form of a known substance, that is polymorphism, then those kind of substances are also not patentable. Now, method of agriculture or horticulture. If you see, India is largely dependent on agriculture and farmers. So this kind of inventions will restrict development of the country. So India has specifically added this clause that method of agriculture and horticulture does not fall under the patentable subject matter. Similarly, if you see literary, dramatic, musical or artistic works, if there's a funny song, a drama, any musical compositions, an artistic work, a painting, these are all skilled by a person. So these person skills cannot be coming under the patentable subject matter because this is covered under the topic of copyrights. A procedure for medical treatment also is not patentable. plants, animals as a whole are also not patentable, but plant an animal which is actually synthesized in lab, and if it is there is any bioengineering involved in this, genetical modification is involved in this, then those kind of things are patentable. A discovery, scientific theory, mathematical methods, software programs, these are all copyrightable subject matters, which does not involve any technology, technical development. So these are also not patentable. A rule of method of playing a game, that's the mental skills, these are also not patentable. A presentation of information, this is also not patentable. So why we should have a patent protection? So if someone has any invention, now if someone has a patent application put and then they get right from the government, so the person who gets the patent rights for the particular technology, they can use that technology by himself for at least 20 years. After that, that technology will come into the public domain. So the inventor, whoever is there, or the owner of the patent, gets the protection for 20 years to the society, and it should add to the industrial development. And then he can distribute it to others. So you cannot copy. Manufacture, if he manufactures the product, again he can sell and become a competitor. And selling, so if he can get it from somewhere else and then sell it. So he can not manufacture, copy, sell. Even he cannot import that product, or he cannot export the product, because patent right is a territorial right. Now, patent protection gives 20 years monopoly and keep yourself ahead of the competitors. Now, here once any technology is very unique and it is commercially successful, then you can even earn through licensing. This is one advantage which you have with patents. So when to apply for a patent application? So many of them actually doesn't know when they have to apply for a patent. So first and foremost thing, any person, whether he's an engineering student or he's outside, even a mechanic or anyone per se, if they are developing something and then something they have come up with a new product or new idea, believe me, it should not be disclosed to any person. So usually what happens is they go and then they say, I got this idea and I want to share this idea. Never share the ideas to anyone without understanding the legalities involved in that, because one idea can change your life. Many people doesn't have this understanding. So important is you should not disclose any of the ideas which may change the world. So whenever any idea is there, so at that time one should come and file a provision application. So if they do provision application, what advantage they get is they can disclose the invention to public without any agreements. So here, for filing an application, drawings are not required, invention need not be complete, and should be able to describe the invention. So only just if you are able to describe the invention that this is my idea, then it can qualify to go for a patent application, for a provisional, that is called a provision application. So any idea per se, any knowledge. So many people do this mistake. They say that it's only the idea phase. Once I develop this product, then I go for patent. That is wrong. So provision application is economical. You reserve your invention and it can be commercialized as and when it can get into the development mode. So that advantages will be provided by a provision application. Now the execution phase, if you see complete specification. So here you need to describe your invention, and it should be able to, you need to tell how this invention can be made and used. Because the patent application has to be in such a way that any person who is expert in that particular field, if he reads that invention or patent application, they should be able to again reconstruct your invention. So this is the criteria. Reconstruction, that is the reason patent application is a completely technical document which has completely giving each and every details of the invention with respect to the drawings and comparison of the invention with respect to the drawings and also to the already existing prior art. Prior art means the inventions that are already existing in public domain. So after filing the provision application, the patent application, the idea can be published anywhere in journals, make paper publications, participate in competitions, participate in conferences, and disclose your inventions. press conferences you can go. If you see, most of them do this and then come for a patent application. So by doing this, what they are doing, they're killing their invention. They're killing their patentability subject matter, because your public disclosure, without filing a provisional application, you lose the right. Because when you are filing the application should not be in the public domain. By doing all these things, you are in the public domain. You are yourself are creating your citation for your application, where your application itself anticipates your uh, application. Your invention disclosure itself anticipates your patent application during the examination phase. Hence, you have to be very, very careful before you publish your invention in the public domain. So at least a provisional application will protect your right. So this is where any person who are in the science domain, who are inventing and creating, doing a good project reports and all, they have to take all these precautions and then go for a patent application, provisional application, and then they have to come back to this case of publishing it in the public domain. So the contents of the patent application, normally it will be title, field of invention, background of the invention, summary, description of the invention, claims, and abstract. Claims forms the main heart of your invention. What you are claiming, what is your invention, gives complete description about it, your invention in the claims. So description, this is a format in which the application has to be filed. So this is all involves completely technical disclosure only. So where to apply? So once you have done the patent application, invention, and then the drafting is done, so it can be done online or offline. So for South India, the application has to be filed in Chennai Patent Office. For North India, Delhi, Kolkata, and Mumbai, based on various jurisdictions. Now, so for the entire South India, you have only Chennai as a patent office. For North India, Delhi. Okay, but compared to online, offline fees are little higher, because physical copies are being now not in much use, but few people still follow physical filing. So there's a slight variation in the fee structure. So who can apply? An individual can apply. So it can be a student, it can be any person, or a company, a legal entity can file a patent application. So a legal entity can be a private limited company, public limited, or society, trust, partnership firm. All these people can become. So whenever these kind of patent applications are filed by legal entities, then there is a legal documentation that has to be done, because a company cannot be an inventor. Company can be an owner, but cannot be an inventor. So an inventor, whoever invents the application, will assign the rights to the legal entity. Then only the legal entity becomes the owner. So there are two different things: owner and a individual. So an individual can be a owner. Now a company can be a owner. An individual can be an inventor. A company cannot be an inventor. Got it? So the requirements, the first and foremost thing, whenever a patent application idea is being shared, including me, except government, because government is the right issuing authority. So you should not have any NDA with the government, because government itself is giving the right. So apart from government, you are disclosing this invention to any person, you should have an NDA, non-disclosure agreement, including me. Someone comes with an invention and they say that, sir, as you are a patent agent and attorney, so I want to file a patent application. Here is my invention. I say, hold on, don't give it to me. First, let us execute a non-disclosure agreement. After that, you have to disclose it to me. So that is the first step which we have to do. So rights sharing agreement, inventors. Now here, many people do an assignment of an invention, either individual or a group of people. Whenever there is a group of people involved in an invention, then there should be a right sharing agreement properly. So people, why this agreement has to be there? Because you are creating a property, intellectual property, for a period of 20 years. That can range from thousands to lakhs to millions of rupees also in future. So if you have this agreement, there, there will be a very good association and relationship later on, because money changes minds. So the invention assignment has to be there. The invention assignment exists only whenever the application is filed in the name of the company or any other individual who is not an inventor. Even if he is an inventor, but in case if there is any arrangement between a group of people that only one person should be a owner, then there should be an invention assignment also in that case. Strategy for filing an application in India or abroad. Now, you should understand that any person coming and doing a business, a patent application, and then he has done some invention, that invention can have very big global significance. Yes, if such global significance exists, then you have to have a strategy, proper strategy to file the application in the appropriate countries. Because if you are doing a business which is related to automobile, and then there's some countries where the automobile sales are very huge, then definitely you will be looking at protection of your invention in those countries, because you have very huge uh, uh, potential market value. Excuse me, guys, for a second. 1 second. Just a second. I need a 1 second break. Sorry for that small break. Yeah. So strategy for filing India and other countries is important. Now, a legal entity. So for government has given a very good, huge uh, uh, schemes. That is, in case if a person is filing as an individual capacity, not a company, then there's a fee discount of 90%. Yes, 90%. Now, in case if at all the government fees is a company is actually a micro or small and medium scale enterprise registered company, then the government fees is reduced by 50%. So this is even applicable for individual for filing international applications as well. That is PCT application. Now, the important aspect is you have to disclose the source of biological material in case if your invention is related to biological material. And there's a declaration of inventorship where the inventors has to declare that I am the rightful inventor for this invention. So this is another requirement of statement of undertaking. So now types of patents, the functional aspect of invention. Yeah, the utility patents, design patents. So utility patents only cover with the functional aspect of the invention, and design patents covers only the shape and appearance of the product. So there's no plant patent protection in India. So plant protection is actually made by the Protection of Plant Varieties and Farmer Rights Act. Now, this provides the plant breeders' rights. So the requirements: one invention, for one invention, one form. So because in case if any application is made which is having two inventions, then it does not satisfy the condition criteria of unity of invention. So now the patent office will give directions to split the invention into two and application. The proof of right to apply the application and list of inventors and company accompanying the provision or a complete specification draft. So these are the basic things that are required to file the application. Now, utility patent classifications. Now, if you see the technology, these are the basic different technologies that are covered under the patents subject matter. Patent process. So you should have an inventor agreement, NDA, invention disclosure to persons concerned, prior art search. Now, what happens here is many people come to us and then they say, hey, we have done a very good research and this is what our invention is all about. But when we again conduct a search and then we share the search results, the invention is not at all satisfying the criteria that it can get a patent protection. So here prior art search plays an important role before taking advantage of whether the patent application can be granted or not. Because patent application follows a complete different procedure. That it will, after filing the application, it will be examined by the patent office and then they say whether they can issue the patent rights or not. In that circumstance, if you don't do the prior art search, then your patent is likely to be get rejected. So this is an important phase. Now the business strategies. once the patent application is filed, within 1 year, you should file the patent application in other countries. Otherwise, you lose your right to file the patent application in other countries. So you should have a strategy right away at the time of filing the application, because you have very little time, very short time to decide on which countries to file. So you should have a very clear strategy, like in which countries I'm actually looking at filing the application. Now, patent drafting, again, in the drafting part, we have to cover the invention completely throughout the length and breadth of the invention, and also protect the future developments that may come in your invention. So the drafting plays an important role in terms of the modulation of your invention, putting down it on the paper, and then give a proper clarity to the inventor, and as well as to the readers, and also to the patent office examiners and others. Patent filing, again, we file the application in India and then later on decide to go in abroad or any other countries. So after you file the provisional application, you can publish your invention in journals, make paper presentations, participate in competitions, participate in conferences, press conference you can do, and mainly you can also participate in the investors meet to get funding for your inventions. So patent search, patent drafting, so strategy preparation, and filing, examination, and here. So as we go with the journey of the patent application, patent search, strategy preparation, drafting, and filing will take approximately 3 weeks. After filing the application, the patent examination may take approximately 2 years. So there is a specific provision provided for startup, and there's a provision provided for MSME company and women entrepreneurs, where a woman is an applicant. Their application can be examined within 3 months of filing the application. So this is an advantage that is being provided by the latest amendment in the Patent Act. So after patent is filed, you can request for an early publication because publication means the patent office will publish the application after 18 months of filing the patent. So after filing this application, after 18 months, the patent office will do the examination of your patent application. So if you want to do the examination, then you should have early examination. If you're coming under the category of either a startup or an individual woman who is an applicant as a woman, and as well as a company with an MSME, they can actually request for early publication rather than waiting for 18 months and then get the patent examined. After the examination is done, there is a review of the patent by patent examiners at the patent office and see whether thus your application is covered under the criteria of patentability subject matter, and they will raise any objections for granting the patent. After they raise the objection, then we will reply to the objection stating that the objections are not valid or granted, and request for grant of patent application. Now, in case if the examiner is not still convinced after giving the response, they will ask for coming to a hearing, a person hearing to support our response. After that, in case if he is convinced, then the patent gets granted. So I give a small example what kind of an invention can get a patent granted. So if you see, there is a small example of a prosthetic hand. So if you see a hand, if somebody has lost his hand, so there's some other artificial hand that is kept, which can actually take some signals from the hand and then do the hand movements. In this case, if you see there's some cone-shaped material that is placed between the artificial hand and the limb, human limb, arm. So now, in case if this is being kept, the signals that have to be transmitted from the limb to the artificial hand are actually obstructed because of this cone-shaped material. So what happens is the electrodes and all are not properly communicating the signals to that because of that conical shape that is there. So this does not also gives not proper fixation and the bonding. So what happens is the cable attached to the electrodes are not able to be used in the liner technology. So there is a cutting of a portion that is being made to the conical shape. Now here there's some electrode and there is a cutting on the conical shape, and then the wires are getting transmitted to the connected to the arm for transmitting the signals. Here, because of that, what happens because of the hole, there is adhesion between the arm and the artificial hand is lost. The positioning of the stump is difficult because the hole has to match with the hand and also the artificial hand. So there will be a discomfort that is caused to the patient because the grip is also lost. So now the invention, what happened? They have just kept a wireless communication between the measuring unit and the receptor unit. That is, if you see here the hand, there is only a here at this part there's a wireless unit kept, and then here this is transmitting the signals wirelessly to here. No need to cut the conical shape. So because of that, you are actually addressing a problem here. Once you are addressing a problem and eliminating that problem, you are going to get a patent. And this is a live example where a patent got granted. So here the problems, whatever addressed before, everything got are lost. See, discomfort to the patient because the grip is lost. So now because grip is very intact, so discomfort to the patient is also lost. So these kind of technical developments are patentable subject matters. So important points research in the patents domain. Research on the existing products has to be there, and research on the existing research papers, journals has to be made, because unless and until you do a research, you cannot get a patent application, because patents means technology, research, and then development and innovation. Unless and until there is invention involved in that, you will not get a patent. So the research on patents filed in the particular domain, you should also do, and you should also identify who are the key players working in that area and analyze their latest developments to avoid overlap, because you cannot get any patent application for already existing patent. So as we already discussed, applying for a patent application and filing fee individually 1,600, a small entities 4,000, and large entities 8,000. So early publication fees is individual 2,500, small entity 6,250, and large entity 12,500. Examination fee 4,000, individual, small entity. So if you see, the large entity cost is 40,500 rupees approximately for a company, whereas an individual the fees is only 8,100. Is nearly less than 20%. So for startup, express examination fee is 4,000. So overview, whenever there is any problem, you do a research for that problem. And if there is any research, and if you are able to find out a technical solution for a technical problem, then you are qualified to get a patent application. So this is what about patents. So far, any questions where you need to, you are having some doubts to discuss about patents, you are feel free to ask me or send your message in the chat. So no questions? Good. Okay. So we'll go to the next topic. That is designs. So designs are actually protected only for the shapes. So sorry for that. How many of you had actually seen Kinder Joy chocolate? So Kinder Joy, it's an egg-shaped shape of a chocolate. So what is unique about that Kinder Joy chocolate is the shape. If you go to any outlet, anywhere, you find that a tray placed with all eggs, like Kinder Joy, where you can get a good chocolate. So that is actually a shape that is driving people to do a commercial activity, purchase it. So shape, you see so many bottles, cars, so many shapes. So these are some of the examples of the shapes which are used in industry. LED fog lamps for vehicles, which are used in automobiles. The shape is only covering the design aspect, nothing technical about it. So this is so any shape that comes in, apart from if you see any LED light or any play toy or anything which is very, very novel, unique, and you have developed it by your own skill, then that qualifies to go for a design application. Now trademark. So this is a mark used to represent your company or your services or your goods. And that can be in the form of a word mark or a logo, a caption, image, or combinations. If you all see, just do it. Just do it is a caption, and it is being used by famous shoe manufacturer Nike. If you see a logo of a Reliance Digital, Reliance Group, it's very easily identifiable. If you see a logo of Samsung, very easily identifiable. So that's a mark that creates that, and word mark is just the same combination of words, letters. So I'm going to just give a small quiz now, and I need all participations. Okay, so there are 32 participants overall right now. So I need at least 50% of you to give a message in the chat. Chat is enabled, moderators.
Yes, sir. Yes, sir.
Okay, so chat is enabled.
And
You can
there is
start.
a
So,
question for the participants,
yeah,
sir.
this is a question for the participants where identify the brand and then message in the chat box. Let me open the chat. So no one has still attempted to answer this. Come on, participants. Yes, Dr. Manoj Gujar. Thank you very much, Dr. Manoj, for giving. It's Hindustan Unilever. Perfect. Now we are going for this one. Ericsson. Perfect. Sony Ericsson. So here now, who needs these trademarks? Who needs these trademarks? So any new company about to be formed or any new product that about to be launched. So any business owner, whenever they want to start a business or launch a new product, a new vertical in their own company, now they should actually look at, there cannot be another Hindustan Unilever can be formed. There cannot be any new Coca-Cola that can be used as a product brand to launch. So now in this case, what they have to do? They have to actually be very, very careful whenever they launch a company or a product, because you're launching a company or a product to do business, not to fall into litigation and then fight in the courts and company regarding the brand names. This is a very small minor thing where this is giving you an identity, and you should focus on the business rather than fighting on your brand name or a company name. So as we say, prevention is better than cure. So before launch or before a company is formed, these things have to be taken care of. So many people do this mistake. Let us see after some time, if someone comes, then we will think about it or change it. Dear friends, someone is looking at you and then they don't want to come down to you very softly and request you, please stop copying my brand. It is similar to my brand. They have remedies, because if the trademarks are registered, they can even file a criminal complaint against you, and an FIR can be launched against you. So this is very important. It is that no trademarks are required at this stage. So if there is no trademark registration, if there is no employment agreements between the employees, so whenever I say employee agreement, as because you all are professors and many of your students will become entrepreneurs. So what happens is that one of your student will come out with a very good idea and then he starts a company. And then after that, the company, he recruits some of the people, and then they start doing business, and he shares that, boss, this is the material from where we are getting, and this is the where we are actually doing the business. And then so entire business channel, everything, the employees knows it. And now he goes outside the company and then he starts using the similar brand names. So what happens is, because you don't have any proper agreement in the place that your employee should not do competitive business, which will affect your business. As an employee, he can go out and do any kind of business, including your business, but he cannot become competition to your own business by stealing away your own clients. So their subject matter, different variations do agree. So, but if you don't have employment agreement, you have very big threat of this one. Now, confidentiality agreement is also one of the important things, because all the employees and employers have to have a agreement before. Otherwise, if you are not binding them by agreement, there is no common law protection, where in the absence of any agreement, you can still claim your rights. No, that is not there. So, because before and after, the directors, partners, employees, everyone have access to the confidential data. The most common mistakes people do is in the business, they believe each other so blindly that they don't even have any terms written in the business. So after that, these people keep having issues of losses, conflicts. After that, they go to the court and then waste their precious time in the courts. So this is one thing that has to be very careful at the time of doing the business. So the trademarks, uh, I'll give you an example, classic example. What happened? There's a couple of people came to us for a partnership firm registration along with the trademark. Then we asked them, okay, so in case if you both of them run into losses, who is going to share the loss to what extent, and what is that you are having a dispute resolution, what you want to have? Before they formed the company, they fought, and then the company, the partnership firm didn't exist at all. So this is a clarity that everyone needs to have. So the business contacts, the raw material procurement, supply cost, confidential formulations, all these things comes here in the agreements. So other issues when the intellectual property comes into the picture is whenever the dispute between the partners, brothers, sisters, now every property or every relation are in trouble and fighting in courts because of all the disputes that is happening. So this unfair competition, mostly it will happen with the employees only. So is an example I would like to share. Please keep this confidential. There is one company where we deal with these polyline pipes. These are the pipes used for electric cabling inside the houses. So these are the pipes that get connected to the switchboards. Now you can see the clear copy of polyline gold being made as polyline, and then with a very low quality. Now this is where people are encashing the someone else brand name, and then now someone who is very well familiar with this brand polyline will understand that this is also coming from this company only, but very little they know that this is coming from a counterfeit, a duplicate company manufacturer. So now this company has to take all precautions that are needed to safeguard their brand name and then protect their interest by in case if this polyline gold fails in the market, people will blame this polyline, not this polyline manufacturer. So this is where trademarks comes into the picture. Now copyrights. When we come out the copyrights, copyright is a software infringement sued by competitors. So software means what? So a copyright comprises of literary, dramatic, all the works which I have already mentioned in the earlier slides. I'll give you. So this one example I am actually giving here. There is one company in India who has collaborated with a US company. They hardly did any business. Now later on, the company in India had developed their own software and they started doing business. Now in this scenario, the company in US sued Indian software company and claimed damages of 2 crores in Chennai High Court. Now, if you see, it's just only a hypothetical situation where they think that you have, because I have discussed with you, you might have copied my software. So copyrights here, whenever any literary, dramatic, artistic works that are there, these rights are also are equal importance and they should be protected with the Copyright Office. So if you have a registered copyright, you will have a very valid advantage of, so, enjoying your rights and also sue others in case if someone is copying them. Sorry, this is actually. Okay. See, the advantages for engineering students in having a patent applications are the better opportunities in higher studies, better employment opportunities, and they can become a better scientist because they are having that research and understanding the problems and giving problems to the solutions alone is the major criteria to become a better scientist. So these patenting activities will give them the bullseye to see how they can actually develop new products and innovative products. So they can be ahead of competitors and then increase the value of the company. So any companies, whenever the companies do the patenting activity, they are actually trying to be ahead of the competitors because patents are going to add to their asset value and they are going to be giving them a very edge with the competitors. So what are the benefit of getting registrations in the of the intellectual property rights? So benefits can be this will be evaluated and then it will add to the assets to the company, and giving a TM or R or C or patent pending gives indirect legal notice to the others that beware of infringement, otherwise we are going to sue you. So you have both civil and criminal remedies against infringement if you have trademark registered with the government of India and then they issue the certificate. Otherwise, what happens is you don't have criminal remedies unless except copyright. You only have civil remedies for patents, trademarks, and designs. Now, once you have registered intellectual property, you can sell, license, execute a will just like any other movable property. So the copycat companies will not cause loss to you because you already intimated many of them that you are a registered owner, and if they copy, they know what the problem they are going to have. So regarding the copyright, the literary works means they are books, novels, poem. All this comes under literary works, so which are books also. Now, dramatic works, the dramas, the public performance activities that are being done on stage works, all this comes under dramatic works. The musical works, all the musical notes, and the literary works, the script of the lyrics comes under the literary works. The musical works has the notes. The sound recording is the sound sung by the singer along with all the music. Now, cinematographic film, the regular films, artistic works, the paintings, the sculptures, you find all this covered under the artistic works. Software, all the programs that are there in the software, which is having the source code, object code, and are software protected. Now, there are two people involved in this. One is author and another is owner. Now, who is the author? Author means a literary, dramatic works, related works. Author of the work is the book who has written. For a musical work, the author is composer. For an artistic work of other than a photograph, artist, the person who makes is the author. So the right is first with the author. The photograph, if someone has clicked the photographer is the author of that photograph. Now, cinematographic work and sound recording, the producer who is producing is the author of that because he is spending money to get the work done. Now, the computer generated works, who causes the work to be created? Many people in many software companies are actually lacking this concept, this understanding. Any software developer who is developing the software in the company is actually the first author of the software. So if someone wants the right of that software, then the owner has to be created and the owner has to have the rights that has to be transferred from the software developer. But this is not happening in the software companies. So unless and until again there is someone sues and then some kind of an issue that arises, then only all the software companies will create interest to get the copyright registrations for all the softwares that they create. Now, coming to the geographical indications. Now, this is another form of intellectual property rights, which is a sign used on products. So, a sign used on products that have a specific geographical origin. See, some specific geographical origin is one thing because whenever we tell that geographical area, then by name, that particular product has to come and strike. So, that is a specific criteria to understand that this product comes from the specific geographical region and that has a quality or a reputation that is due to that origin. So I'll give a classic example coming to this part in the next subsequent slide. Now, this one small quiz. Just identify and then give me the answer in the chat box. What product comes to your mind if you see this geographical area? You need not be specific about the product. Whatever comes to your mind, clicks, you can answer it. Gadwal. What comes to your mind immediately if someone listens the word Gadwal?
Saris, of course, sir.
Tough saris, of course, saris. That's a wonderful answer. So next, tea. Correct, tea. Arundhati movie. Nice answer. So you might be watching more movies, right? Kondapali. Toys. Absolutely right. Nirmal. Nirmal paintings. Paintings. Nirmal comes out the paintings. Tirupati.
Laddu and temple.
Yeah. Exactly, Laddu. So these are all actually registered geographical indications, and no one can actually keep. If there was a classic case where a sweet shop was selling a sweet as a laddu, and he named it Tirupati Laddu. Immediately, a case was registered against them, and they immediately removed it. So a person cannot copy a specific product of that particular region and use it in his commercial activity. Now, he's selling that laddu as a commercial activity. He cannot do that. So that is where this intellectual property rights comes into the picture for protection. So any place, anywhere where you see a group of people are involved in doing some activity, and that area, that region is famous for that particular product, that itself is a valid criteria to get a geographical indication register. Next, coming to the part, some examples what I had taken out from the uh, registered geographical indications in India. You see, these are all the foodstuffs, and these are all the states from where these are all applied. If you see, you can see in the states, you see a country called Ireland. It is manufactured, and they are targeting this Irish whiskey. Now, this word Irish whiskey should not be used because that is registered as a geographical indication by Government of India. So, Indian government recognizes their registration. So no other company, liquor manufacturing company, can refer their whiskey as Irish whiskey now. So similarly, if you see so many Kandangi saris, Palvoka, and so like this, and some of the other geographical indications, you see Guntur Sannam Chilli, agriculture Andhra Pradesh. Gadwal saris is also, you can see here, from the bottom three. Bikaner Bhujia. If you see the Bhujia also. Yeah. Going to the next. Trade secrets. This is something very important topic. This is actually trade secrets. Trade secrets means this is something commercially valuable because it's a secret. So because when there is some kind of a composition, some mixture, and it has got a huge demand, so people doesn't know the recipe. So all the recipes, the formula, the mixture, the composition, these are basic criteria that is not available anywhere in the public domain. And even they don't want to protect it, because if they protect under the Patents Act, they have to disclose everything to the public. Then after 20 years, they no longer can be monopoly. Many competitors will come, and then subsequently there will be many more owners that comes in. If you see the KFC, even the KFC spices are very, very confidential. Coca-Cola composition, that is also very, very confidential, and the composition is not known to anyone till date. So this is no, second one is be known only to a limited group of persons, because they carry it as a tradition and a custom, not to copy through any other person from these persons. So even there's a very huge confidentiality that is being maintained even by the people who are there. So they don't know who are the other people who are working in other composition areas. So very difficult for such kind of compositions to be leaked outside if you do take a proper protection during the manufacturing processes. So there should be a subject to reasonable steps taken by the rightful owner of the information to keep it secret. So here the law says is, for the company, what steps you are taken to safeguard your intellectual property rights, your formulas, your secrets. So here the confidentiality agreement plays an important role. The non-disclosure agreements gives an important role here. Sorry. Trade secrets, it can consist of a manufacturing processes, pharmaceutical test data. See, pharmaceutical test data, that's not that easy, often available in the public domain, because a series of tests under the lab using different machinery, equipment, conditions, these tests are done. So the data that is being generated is very, very crucial and important for the pharmaceutical company to create any drug. This test data cannot be leaked outside. So this is some kind of a data that will be kept as a very secret. The design and drawings of computer programs, etc. Because huge computer programs run into thousands of pages. There will be a specific scheme and a process, a flow chart to execute that. So that is one important aspect. Commercial information, distribution methods, list of suppliers and clients, and advertising strategies. All these things are also coming under the trade secrets. So here, in a nutshell, I would like to give you all the information about whether the registration is mandatory or not, and how much duration these intellectual property rights are protected, and public disclosure before the registration is acceptable or not acceptable. So if you see patents, the registration is mandatory. Otherwise, you don't get patent rights. And that duration is 20 years, and it is not renewable. So after 20 years, up to 20 years, every year the patent application has to be renewed. But after 20 years, it cannot be renewable, and it comes to the public domain, and anyone can manufacture that product. And public disclosure before registration, this is something very important. So you should not disclose it to public before applying for patent application. Once you apply for patent application, then only you can disclose it to public. Now coming to the trademark registrations, trademark registration is not mandatory, because there are so many brands that are there which are not registered still, but they are still famous brands. So people who doesn't have registration still, they own right under the common law, and they can seek remedy only under civil action, not a criminal action. So trademark registration is recommended, because once the trademark gets registered, you get rights for criminal action as well. And public disclosure before registration, yes, that can be there. Copyright registration also, it's not mandatory to have a copyright registration, but yes, if you have registration, so basically once you have copyright registration, the burden or evidence of existence of the product under your name and you have the right need not be proved again. Because already you got the registration and you got the certificate from government stating that so and so copyright is in your name. So 50% of your job is over. You are easy now. You are relaxed. You can easily submit that certificate to the court, and then you can take action. So the duration of that copyright is the lifetime of the author plus 60 years. So this is very, because these are all author-based products. So this is 6 plus 6. So my coverage is very, very huge for this copyright. Unless, okay, trademarks, it is a very, very long until and unless you withdraw the application every 10 years, it can be renewed indefinite period of time. But copyrights, yes, lifetime plus 60 years is the end time. Public disclosure before registration will not have any impact on the registration. So for any copyright, yes, you can launch the book and then go for copyright. no problem. Unlike patent application and design also, it is strictly no. That it should not be disclosed to public, and then it should be filed immediately. Okay, and the duration is 15 years. Geographical indication, registration mandatory, yes, and duration indefinite, because as long as the earth exists and the society exists where these people start generating uh, the geographical indication goods like saris, laddu, toy, all these tea, everything that as long as they exist, they supply, these rights do exist. And public disclosure before registration, yes, it can be exist, no problem. That will not stop you from getting the registration. Now the trade secrets coming forward, registration is mandatory, no. Duration indefinite, and public disclosure before registration, it does not exist at all, because they are keeping it as a trade secret. You are not letting this information go out at all. But yet this trade secret is accessible to some of the few important people in the organization, but not completely, but bits and pieces, how you strategize. So there, that is where these three things comes into the picture. So trade secrets have technical manufacture process. Yeah. So this is the end of my presentation regarding the patents, trademarks, copyrights, designs, geographical indications, and trade secrets, friends. So if you guys have any questions, and I'll be glad to answer your questions. I hope I'm on time. We have at least 20 minutes for us to have an interactive session, because as I mentioned, this should not be a one-sided session. So if you guys have any questions, I'll be glad to answer.
Yes, sir. There is a question from a participant like drug formula comes under which IPR?
Drug formula comes under two. One is, if it is not disclosed, that can be protected under the Trademark Act, under the trade secret. But if you want patent rights, yes, you can go for patent rights as well.
Okay, and the other question, how much time it takes to grant a patent?
Typically, for a startup company, if it is filing in the present scenario, thanks to Modi government, it will take approximately 6 months minimum. Previously, it used to be 4 to 5 years and even more. Now it has come down to 6 months. And maximum time, it will go up to 2.5 3 years, not more than that. We are right now very good, competent with patent office in like USA. Even US patent applications take minimum of 2.5 to 3 years. They are on par with the developed countries in this regard.
Thank you, sir. And one more question.
Yeah.
So what licenses do you use for 3D printed objects?
See, 3D printed objects, frankly speaking, as a patent attorneys, we don't use any softwares. We do patents. We have softwares for doing the research analysis for patents, IPR services related. So for 3D printing, definitely we are not going to use any softwares, but the 3D printed object, if it is created, they want to go protect it, that object that goes under the Designs Act, because 3D printing shape, you give any shape, it will just print, right?
Yeah.
So Designs Act is the best act to protect under the rights under the design printing. Because a prototype can be created within minutes, the printer capacity. And just you give a hypothetical drawing and then give it to the input, it will print out and give it to you.
Okay, and the last question about the trademark dates.
Hmm?
So the meaning of the trademark dates.
Trademark dates.
Yeah.
Can you elaborate the question? What exactly mean by
So
trademark
only
dates?
this much is given here, and
Hmm?
only trademark dates. So what means any dates are there for the trademark? So what is the meaning of the trademark dates?
Trademark date, I'll tell you. There are so many people who file the trademark application. The mistake what they do is, so many filing companies and agencies what we have come across, there is a very significance of the trademark usage date. That is, if at all a trademark is not filed till date, but they are already in the business. If they are in the business, then they have to protect the brand name. Like if they are in the business in the year 1999 or 1990. So from 1990 till now, it is 30 years. Am I right? So now
Yeah.
if they want to file the application on this date, they should not file the application on this date saying that I am using the trademark on this particular date. They have to claim that we are using it since 1990 and provide proper evidence of their use for the past 30 years, because here the registration is not that much important. Registration by using from that date, trademark date, is important. That is, I am filing the application in 2020, but I have to file the application saying that I am using this brand from 1990, and then getting the seniority of that brand registered on today's date is important. Got my point?
Yeah, okay.
That is
Thank you.
important. The term of the design is 15 years. Can it be renewed? No, the term of the design actually is 10 years. And after 10 years completion, we have to apply for renewal again under the Copyright Act, renewal of copyright. So that 15 years is covering that 10 plus 5. After that, it cannot be renewed. Jyoti asked, what is the education qualification for IPR attorney? IPR attorney, now there's a difference between advocate and IPR attorney. Advocate is person who is practicing in the courts. Now, an advocate who is also a patent agent with Government of India, registered under the Government of India, he is called IPR attorney because he is qualified in both the segments. Like he can practice in the courts, and he's also practice before the patent office. So IPR attorney covers both. So law plus engineering is, or science background is important, and with that science background, you should qualify as a patent agent with Government of India for patents. But it is not essential to get registered yourself as a trademark attorney if you are a lawyer. So the trademark agent examination also you can qualify. Sir, any expiry date like kind of for patents? Yes, patents expire at after the end of 20 years.
Thank you, sir. Thank you so much
Thank
for
you
a
very
very
much.
informative session and in-depth insight on copyrights, trademark, design, geographical indicators. So now I would like to, and now I would request Miss G. Sunanda, IQAC coordinator, to give vote of thanks.
Thank you, Kavita.
Thank you, ma'am.
Thank you. Good afternoon, one and all. Respected Principal, Dr. P. Sunita ma'am, Vice Principal, Dr. Rashmi ma'am, and the resource person, Mr. Naveen sir, all the participants, the conveners of the webinar, and all my colleagues. I, Sunanda Geeta, the IQAC coordinator, and the faculty from the Department of Computer Science, are privileged to proposing this vote of thanks on behalf of the college team and the participants for this online national FDP. I sincerely thank our guest speaker for the day, Mr. Naveen sir, for the advocate and IPR attorney, for accepting the invitation and sharing with us those valuable inputs. Sir has given a very much clarity on the IPR, that is patents, trademarks, copyrights, trade secrets. You have told about this, what can and cannot be patented. Sir has actually made this entire session engaging with his short quiz sessions. Thank you, sir. We wish for your success on your mission of the helping 10,000 entrepreneurs, sir.
Thank you very much.
I also thank our management, Principal ma'am and Vice Principal ma'am, for having been the strong pillars of support in all the events of the college. I thank and appreciate the Department of Commerce and the conveners for their initiative and the sincere efforts in organizing this faculty development program. I also thank all the participants for showing interest and participating in the program. I hope your motive has been met. I thank the ICT team also for their technical support. I thank each and everyone who are involved in this. Thank you. Thank you once again.
Thank you.
I
Thank
think
you
the
very much.
feedback form is, yeah, thank you, sir. The feedback form has been posted in the group, posted in the chat box. Please fill the form.
So, all right, then I can take a lead.
Yes, sir.
Thank you, sir. Yes, sir. Thank you, sir.
Thank you very much. And I thank all the participants also for being a wonderful audience, getting interacted with answering all my quiz. So I hope you all enjoyed the session, and my contact details are there with the organizers. You all can take my contacts, and then you all are free to contact me anytime, either phone or email, and I'll be glad because as I am on the mission of helping all the 10,000 entrepreneurs. You all may also be a part of that 10,000, and I'll be glad to guide you all to make a successful career ahead. Thank you very much, one and all. Thank you, Kasturba College, for giving me this wonderful opportunity. Thank you very much.
Thank you, sir.
Thank you, sir.
Can I stop the live session?
Like, yes, Vidya. Yes. Sorry. I forgot that.